so let's actually get started because this is obviously I'm really interested in this topic, and I don't want to run out of time here. But um, so when you think about a CIU or a conviction review unit or a conviction integrity unit, how do you define that?
How do I define that? So a conviction review or conviction integrity unit is a specialized unit within a prosecutor's office that is looking both to identify past wrongful convictions, and they can define that in different ways. All of them use the common actual innocence, that the person who was convicted of the crime had no involvement in it. Many go beyond that, where there was a very severe constitutional procedural violation, such that the person should not have been convicted. And then that unit also looks backwards to learn from those wrongful convictions, those errors in the criminal legal system, to prevent them from happening again. So looking at cases deeply, doing what we refer to as root cause analyses or sentinel event reviews to see what happened and how did that error occur and how do we prevent it from happening again. So it's both a forward and a backward looking unit at the same time.
That makes sense. And before I get too far along, can you pronounce your last name for me, just so I?
Sure, it's Bluestein, like Valentine.
Oh, Bluestein. Okay, and it's the Quattrone Center.
Ready? It's the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School. And I am an assistant director.
And what's your title?
Assistant director.
Assistant director. Okay. So Quattrone obviously works with conviction integrity units around the country.
Right.
And you guys have been described as the experts when it comes to CIUs. So what makes you guys an expert when you talk about data? I mean, how you go about looking into it.
So what makes us experts is we were the first center to look systemically at conviction integrity units back in 2016. Our executive director, John Hallway, surveyed the then 27 units in the country to kind of see how are they operating, what were the commonalities, what were the identifiable best practices, pardon me, at the time. And so since then, we have gotten several grants from the Bureau of Justice Assistance to help with conviction integrity units and innocence organizations, usually small nonprofit or university-based organizations that are also looking into wrongful convictions. And we provide technical training and assistance to them all around the country. So through that work, we've also continued our work of surveying units, trying to understand what's working, what's not, what are barriers to success, what are helpful things to success. We run seminars every month for folks who are doing wrongful conviction work. We've done several guideline programs or projects on data collection, data analysis, on best practices, collaborative agreements, working with unrepresented people, which is a constant issue with conviction integrity units. So we're just immersed in this issue, and we work collaboratively and cooperatively with these units all around the country.
Okay, great. One of the databases I often look at when it comes to exonerations is the University of Michigan.
Right.
So they kind of break it down into conviction and integrity units that have had an exoneration and those that have not. Right. And what you find, and what I've heard anecdotally, is that about 50% of them, never even exonerate anybody. So that's why right. Is that?
So first of all, the National Registry of Exonerations is the absolute key to understanding exonerations in the United States. It's the only existing database. And it's not just about tracking the cases. They track deep data to try to understand these phenomena from a lot of different angles. But they are focused on exonerations, which they define very particularly as somebody who was convicted of a crime and then has their conviction reversed based on evidence of actual innocence. So, we absolutely need to track that. It's critically important information. But what people don't really understand is with exonerations, they're a relatively rare event because it takes such an amount of luck to be able to have all the dominoes fall in precisely the right way and order in order to reach that level of confidence that the wrong individual was convicted of a murder or a crime. More likely, the evidence supports that the conviction was wrongly obtained, or that there were errors in obtaining the conviction, like evidence was withheld from the defense. That we call that a Brady violation after United States Supreme Court decision Brady versus Maryland. Or the trial lawyer was ineffective, didn't provide the right level of support and advocacy that should have been done at the trial level, or there was a bad forensics, or a number of other factors that can lead to it. So it's more likely that we get to the level of, we don't have confidence in the verdict, but there might still be some residual evidence of guilt. So in those cases, what will happen is a CIU will very often do what we refer to as a case correction. They will go into court, support, pulling that conviction back. Some states call that a vacatur, or just vacating the conviction and the sentence. But then because there's some evidence of guilt remaining, then the individual either will be retried, or they will usually enter into what we call an Alford plea, which is like a guilty plea, but allows the individual to still maintain their innocence, but saying, I'm not contesting the evidence that could be presented. Those case corrections occur at a much higher rate than do exonerations, just because exonerations are such a rare event. So it's, for CIU purposes, yes, they may not have had exoneration, but very often they have had case corrections, or they had other things where they have taken action on cases that don't rise to that particular level.
Okay, yeah, I get that. But there are clearly some CIUs that do their jobs much better. And I think of the Wayne County Conviction Integrity Unit up there. I mean, they've had more than 40 at this point since they opened in like 2018, right, where they've either freed people from prison or given them some sort of judicial relief.
That's right.
And then, there's others where they just don't do a whole lot as far as any type of judicial relief. So what makes a conviction integrity good, and what makes it bad?
So we would say that what makes a conviction review unit good, or conviction integrity unit good, is, are they trying to adhere to what we know to be best practices? Is the unit independent? Is it outside of the trial or appellate divisions within the prosecutor's office? Is it run by a person who has extensive experience in the criminal legal system? It can be a career prosecutor, but it's more likely to be somebody who has defense experience. We know that of the units right now, more than half are run by somebody who had defense experience in addition to prosecutorial experience, to give them that kind of a less biased view of what they're doing. Are they flexible? Do they look at cases, even if the person pled guilty, for example, or if there are other reasons, either statutory or procedural barriers to looking at a case? Do they try to avoid bias in any way? Like, are they, when they're looking at a case, do they not involve the trial prosecutor or the appellate prosecutor, other than maybe as a fact witness? But that person should not have a say in the outcome or have a vote, if it will, right? That person should be kind of walled off from the investigation as a whole. And it's not because that person would try to kind of gin the outcome, if you will, but because we're all human beings, we operate under certain biases. And I mean bias with a small b, like unintentional things we do without even thinking about it that are uncontrollable. And one of those is confirmatory bias. When we reach a decision, we tend to look at evidence through a lens to affirm that decision rather than back off from that. So protecting against bias is a critical point. We'll also look at things like, how many cases did they review? How many got through an initial stage? How many investigations did they do? What kind of, did they involve defense counsel? A very critical part. How collaborative are they in an investigation and looking to see whether a case should be corrected or not? Those are some of the harder factors to look at because they're harder to trace. But part of that is also transparency, which is the final area, which is how transparent are they? Do they tell people this is what our system is? This is what our process is? Do they let people know like what their criteria for selection are? Do they let them know what their decision-making process is? All of that is part of the transparency, which is the final kind of pillar, if you will, of best practices. So if a unit has no exonerations and no case corrections, then we can look at any of those factors to say, well, maybe there's something that could be adjusted. For example, maybe their filter is, they're too tight and they're not flexible enough in terms of cases. So for example, requiring somebody to have new evidence when they apply is not a best practice. because the person has been convicted. They're usually indigent. They don't have the resources to be able to investigate the case. And when you look at the National Registry of Exonerations, those cases that are listed as CIUs and exonerations, most often that evidence that is used to exonerate them came up during the investigation, wasn't known beforehand. That's what the investigation is for. So if you have that as a criteria, you're going to automatically be excluding people who you actually might want to be investigating. Right? So having too narrow a focus on your funnel means you're not going to get that many cases through.
So I would think it could go the other way too. If you're too broad, then I mean you can't accept everybody who says, "Well, I was innocent and the
Sure.
criminal justice system screwed me." I mean, you
Right.
can't do that. So when you think about criteria for selection, what do you like to see?
So it should be non-arbitrary, of course, right? So it's jurisdictionally bound. Prosecutors can't go outside their jurisdiction, so that's an obvious one. Usually people want to focus on people who are incarcerated. People who have completed their appeals is very common, because if the appellate system is going to work, then there are very limited resources on the CIU, maybe better spent on other cases. Right? So those kinds of things in terms of like getting in. But and you're right, if somebody can't say, look, I was somewhere else, I wasn't even there. And these are the people who would have said that if my lawyer had called them at trial, for example, or the only witness and evidence against me was eyewitness testimony, which we know is not, has some issues in terms of eyewitnesses' memory being contaminated by bad police practices. And they wind up identifying somebody who wasn't even there. Or I gave a confession, but I was coerced into that confession. I didn't understand what I was doing. So even if they don't have particular evidence, we can still look at cases where we know there are certain factors that lead to wrongful convictions. And if a case has some of those or all of those or many of those, then that's a case that's worthy to be looked into.
Yeah. And I know I said what makes a bad CIU, and I don't want to say bad, but what's the biggest mistake that a CIU might make?
So I would prefer to think of things as insincere conviction integrity units or insincere conviction review units. So if they don't have if they're a larger office and they don't have dedicated staff, for example, right? It's only one person and they have this responsibility plus another responsibility plus something else, right? It's like President Biden would say, right? Don't tell me your values, show me your budget and I'll tell you your values. Well, if they're valuing the CIU or CRU, then they devote resources to it. They devote a staff, they devote infrastructure, they devote an investigator. That's a key factor to be able to look at. If they have a CRU or CRU, is it even on their webpage? Do they advertise it? Tell people how to apply and what to do? Or is it kind of like hidden behind? If they do an investigation, is it what we refer to as a black box investigation, where they say, okay, we're going to look into your case. We'll let you know when we have some information. Or do they involve defense counsel? Do they involve them in the investigation and conducting the interviews and searching for the evidence and conducting the testing? Are they collaborative in nature? Those are some of the things that we look for in terms of a good, well-functioning, sincere unit. One which is not transparent, does not have full-time dedicated staff, it is within the appellate unit of the office or even the trial unit, or doesn't report out some of that information or doesn't collaborate. Those are some signs that we would say maybe you could rethink how you're doing your unit to be more collaborative, to be more engaged, and to be able to get to those end goals more quickly.
Yeah, so when you think about investigating a case, and obviously there's legal investigation with everything done by the book, but there's also like, was this guy really not where he says he is? And you kind of got to go out and knock on doors
Absolutely
and
right.
whatever. So tell me about the investigative component. What's important there?
So the important thing about investigative component is to not approach it like you're trying to kind of gin the outcome, right? We're not approaching people in doing investigations, and I've done dozens of them. We're not approaching people to say, is what you said at trial true? But rather we're talking with people through a cognitive interview process, a more open and engaged process, asking them for their memory about what they remember seeing, what they saw, what they heard, what they experienced, what happened when they were interviewed by the police. We ask those open-ended questions to really try to understand their actual memories of that. Did they have a reason to kind of sway their testimony one way or another? So we're looking for witnesses, but of course we're also looking for physical evidence or evidence that can be tested, either through biological testing like DNA or even ABO blood typing, or reconstructive issues, or even sometimes chemical or ballistics issues. We're looking at evidence that can be retested. We're looking for witnesses who didn't come forward before, or who came forward but were kind of told, no, we don't need your help. I literally investigated a case about somebody who was right behind the car in which the victim was murdered and was told by police, we don't need your testimony. It's inconsistent with other evidence we have developed, right? Those are big red flags that we look for in terms of doing these investigations. But you're correct. These are intense, these are factual investigations. This is not just looking at the record. This is not just reviewing what happened before. This is going out, looking for witnesses, investigating a case as if it were a cold case, and trying to find out where does the evidence lead. So it's a factual investigation. It's not geared toward affirming a conviction or overturning a conviction. It's where do the facts go? And that's what a CIU is all about.
And when you think about who's doing that investigation, I mean, obviously attorneys do investigative process to some degree, but there's also private detectives. There's so who should do that investigation?
So it frankly will vary depending on who the witness is. Different witnesses really require a different level of experience or approach. I wouldn't send necessarily somebody who's been a longtime police officer out to speak to somebody who might be somewhat fragile. I might want somebody who has victim services experience or some other social work background. You want somebody who you want to approach that in an open-ended way. You're asking open-ended questions, not closed questions. So a lot of it depends on how that interview is conducted with the witnesses. And if it's a critical witness, then somebody from the defense and somebody from the prosecution should be part of that, unless there's security reasons or other reasons that can't happen. Sometimes the defense lawyer is the better person to do that investigation. Sometimes it's the prosecutor. So it really should be a team decision on how each witness is approached and in what order and by whom. That's why the collaborative really works, because the defense will have access to witnesses that the prosecution doesn't have, and vice versa. So it's about making those decisions as a team to try to kind of say, where should we be going next?
Gotcha. So when a CIU is first getting off the ground, what's the first thing that unit should do, put in place, and then jump off from that point? So what's the first thing they should do?
So the first thing that they should do is make sure that they have an independent eye with the elected, right? There has to be that independent avenue of communication with the elected or the appointed prosecutor. It has to be independent. It has to be outside of the appeals or the trial unit. They have to be well-resourced. Then they have to decide, okay, how are we going to flow these cases? What are our decision points going to be? What are we going to determine which cases we're going to move forward? What are we going to determine of what level are we going to make a decision? Who's going to make that decision? Are we going to have an advisory board that helps us to help, again, remove bias from the process? Are we going to involve outside folks? Are we going to involve defense counsel? So a lot of it's just setting that infrastructure up, because once those letters start coming in, you can't build the plane while you're flying it. It has to be built first. So we always recommend just take a few steps back, put the unit together in place, following best practices, and then you can say, yes, we are open for business. We're ready to go. Because then when that letter comes in, who's going to open it, who's going to read it, how is the data going to be collected, who's going to make the decision of where it goes next, what level is that going to be where it goes next, what are they going to collect at that point, when are they going to involve defense counsel? All of those big decisions have already been made. So then they can start right off the bat with submissions from counsel or from individuals to be able to look at cases.
So when you say advisory board, is there like a public advisory board that some CIUs use?
Absolutely. In Minnesota, for example, through Keith Ellison's office, the Attorney General of the state, they have an advisory board that looks at cases, that looks at to kind of gets the final report before it's released to the public. Those meetings are public. They're held on Zoom every month. People can tune in and watch, and they could hear what's being said. They publish the notes of those meetings. The only thing that's not made public are things which are required to be kept private because of state law and other concerns. So there might be an active investigation. Obviously, we can't be having that out in the public, but absolutely, those can be and are public events throughout the country.
Hmm. Um, so how many CIUs have you guys worked with?
A couple dozen. There are about
Yeah.
125 by our count in the United States right now. We've probably worked at some level with at least 80 of those, just either on one-off consultations or meeting every couple of weeks with a new CIU director to help them as they're navigating those waters and trying to put in practice their policies, their procedures, write their application, think about data collection and analysis, all those issues. So quite a few.
Do you know whether Lucas County in Toledo has reached out to you for help?
I don't think they have. If they have, I apologize. I haven't. It hasn't kind of made its way to me. But we are happy to work with any office that is starting up. Like I said, very often we just kind of send a lot of materials along for a CIU to look at. We have a website, convictionreview.net, where most everything is posted, and they can go and read it for themselves. And then we always offer to set up an initial meeting to talk through issues or see how we can be helpful. And then sometimes that turns into biweekly or monthly meetings as long as the unit needs it. It's really up to the unit to engage at that point.
Yeah, and so I was going to ask, okay, so if Lucas County wanted your help, what's their best way to get your help?
So they can just reach out to the Quattrone Center. It will come to me directly at my email or to calling the center, or even on the convictionreview.net website. My contact information is on there as well. We try to make it fairly easy for folks to engage with us, but of course we're constantly looking for new units and new ways to help out as well.
Yeah. So let's just leave with the final statement. I think there's little doubt that America is at this point in its history where they are willing to take a closer look at some of these wrongful convictions or claims of innocence, which 20 years ago they weren't. So there is kind of that shift in American society today, but at least in my opinion. But I mean, yeah, just give it one final statement about why it's important. I mean, why is CIU important? And just creating like faith in the local justice system.
That's exactly what it is. So creating a CIU or CRU is a statement to the community that you take all convictions seriously. You want all convictions to have integrity. All convictions should withstand an investigation and review. So it is about identifying past injustices. And to be clear, this is not outside of the prosecutorial function. This is core to the prosecutorial function, ensuring that every conviction has integrity and every conviction should stand. But when those cases are identified where there was an error, procedural error, constitutional error, factual error at the trial, where there was erroneous information which was provided to the fact finder, be that the jury or the judge, or even the guilty plea itself, we have a duty as a society to rectify those, because we have to have a criminal legal system that bears the full faith of the constituency. And unless we're willing to recognize error and correct them when they happen, that faith gets shattered. And remember, it's not just about looking backward, it's about looking forward. Because the best way we can prevent wrongful convictions is by learning how they happened in the past. And by doing root cause analyses and sentinel event reviews, which aren't about blame. It's not about looking for one individual to hold responsible for an entire system's errors, but we look at cases from the system's perspective. Because it is never, ever, ever one issue that causes a wrongful conviction. Never. Not in a false confession, not in an eyewitness identification issue. There's always systemic, kind of backstops to prevent that error that failed. And so by looking at it together as a system, that's how we learn, that's how we prevent it. But these units are critical to restore the faith of people in the community that this jurisdiction, this prosecutor believes that only the right person should be convicted. They should get the right sentence and be held accountable for the right reasons. And if any of those fail, then we need to correct that in order to have the right faith.
I love this interview. So thank you so much. I mean, and thank you for the important work that you do, obviously, and I am certainly hoping that Lucas County they get a vibrant, successful unit here, because we certainly have had some issues, and I look forward to the conversation down the road. But thank you so much for.
Oh, it's my pleasure. And I very much hope that the Lucas County folks reach out. We'd be absolutely thrilled to work with them and do everything that we can to help them out.